Now, a civil society organization is demanding a key amendment to the Criminal Procedures Act be implemented. It allows for bodily samples to be taken from certain people for the purpose of DNA analysis. Action Society has instructed its lawyers to prepare to sue the presidency, the police commissioner, the Minister of Police and the Commissioner of Correctional Services to ensure this happens. It sent a letter to government in August demanding the urgent implementation of the Forensic Procedures Act and the Convicted Offenders Bill. It gave government 30 days to comply. For more on this, Vanessa Lynch from DNA for Africa joins me now. Vanessa, good afternoon. Thank you so much for joining us. Why is this important, this piece of legislation important for you?
The DNA database, which is currently in place by virtue of the DNA Act, one of the central indexes is in fact the Convicted Offender Index. And in the first 2 years of the DNA Act's passing, they were enabled to collect DNA samples from convicted offenders. They were given 2 years because it was such an important population to put on the criminal offender database, but they weren't able to sample the entire convicted offender population in the 2-year period. There was an extension requested by the Portfolio Committee to the Presidency to say, please, can we continue to sample the convicted offenders before they're released from prison? And this still hasn't been signed. Essentially, this Convicted Offender Amendment Bill is requesting the continuation of sampling of convicted offenders. The reason it's important is that it's a deterrent. It solves cold cases. We've seen offenders who have been convicted of a common assault being linked to over 30 rapes. And it also identifies those offenders if they go back to crime. Immediately they have the DNA on the database and they can link them to an identified person. So in a scenario where we have a huge reoffending rate, where we have gender-based violence as a central issue to our crime pandemic in this country, it's just not really rational as to why this DNA bill is not being passed.
So let's simplify this, because all you're asking for is that these are Section 8 offenders, that we have their DNA in database so that if there is a crime committed of that particular nature, you can quickly go in and test and find out, okay, this is the person that we're looking for. That's simply what we're asking for, what you're asking for here.
Correct. There are many convicted offenders who are currently in prison who could also be linked to cold cases or to other rapes or crimes that they still haven't identified the person. So that's one aspect. They can solve cold cases. And the other aspect, as you say, is that they can quickly identify a perpetrator if they continue to commit crimes, if they go back to raping or if they go back to crime once they're released from prison. It's very simple. It's not a huge population it's a finite population to sample. It doesn't overburden the forensic laboratories. It's a simple test, a buccal sample. And there just doesn't, for the last 4 years, this amendment bill has been sitting with the Ministry of Police, with the Presidency, and it hasn't been signed. And the question now is the letter of demand that the Action Society has sent through is to say, we are forcing you to either respond to us and say, give your reasons why you're not signing it, or go to the Constitutional Court to say that our rights are being infringed by virtue of convicted offenders being released without their DNA sample being taken.
Now, Vanessa, still on the DNA issue, I mean, the South African Police Services Forensics Division, there's a major DNA backlog in the first place. Even if this bill is signed, how far will we progress with it?
Well, they are making huge inroads into alleviating the DNA backlog. They've also engaged with 2 private-public partnerships with laboratories that can easily process reference samples. It's not a particularly complicated procedure. So you can't, by virtue of the systems not being perfectly in place, which they are getting to that point, just simply allow this to continue. They need to be done in parallel. We need to have a concerted and collaborative effort to ensure that the criminal population database, which we currently have, has the correct people on the database. We can't be taking samples from arrestees and even survivors of gender-based violence and putting those on the database and allowing convicted offenders to be released without their sample being taken and their profile being included on the database. It just doesn't make sense. So as I said, it's not a huge population. It's not going to overburden the forensic science laboratories. It can certainly even be taken on by private-public partnerships for that finite population. And we need government to be accountable to why they won't sign this bill or just for them to sign it.
And lastly, Vanessa, how much is this impeding our fight against gender-based violence?
Well, the case of McKee is a very clear example of somebody who was convicted of a common assault and he was imprisoned. And at the time we were able to take DNA from convicted offenders, it was taken. And that profile was entered onto the database and linked to 30 rapes of young women, under 16, some of them. If he had been released without his profile being taken, he would have continued his rampage. That illustrates clearly why it's so important in the fight against gender-based violence to ensure that samples are taken before release from prison. A number of these convicted offenders are rapists.
All right, thank you so much for your time this afternoon. That's Vanessa Lynch from DNA for Africa.